Good morning, Your Honors. This is case number IT0484-BST, the prosecutor versus Ramush Haradinaj, Idriz Balaj, and Lahi Ibrahimaj.
Thank you so much, Mr. Registrar. Could we have appearances for the day, please, starting with the prosecution?
Yes, good morning, Your Honours. Paul Rogers for the prosecution, together with Mr. Aditya Menon, Ms. Daniela Kravitz, Ms. Barbara Goy, and our case manager today, Ms. Lena Pedersen. Thank you.
Thank you very much. And for the Mr. Haradinaj.
Good morning, Your Honours. On behalf of Mr. Haradinaj, Rodney Dixon, assisted by Andrew Strong and Annie O'Reilly.
Thank you so much. For Mr. Balaj.
Good morning, Your Honors.
Good morning, Mr. Guysmith.
Ramon Baquero, our intern, who was with us for the last time today. He is actually going to be catching a flight. He's been with us for a short period of time. I want to thank him much for the short period of time that he's been with us. He's been of great help, but I wanted to at least acknowledge his presence and his help.
Thank you so much.
Kenti Zaberi, Holly Buchanan, Colleen Rohan, my co-counsel, and I am Mr. Corguy Smith, representing Idriz Balaj.
Thank you so much. And for Mr. Ibrahimaj.
Good morning, Your Honours. Richard Harvey, assisted by Mr. Paul Troop, my co-counsel, Luke Bernish, my case manager, and Ms. Sylvie Kinabo, who is also having her last day with us as our intern, and she has also been an invaluable assistance for the entire period she's been with us.
Thank you so much. Thank you. Mr. Guysmith.
Thank you, Your Honor. One of the themes that the prosecution has asserted in its case is that Idriz Balaj was always with Ramush Haradinaj and always at meetings. And with regard at least to the meetings in Yablanica of the 23rd of June, the 1st of July, and mid-July 1998, the exhibits relied on do not support the contention made. For the 23rd June 1998 meeting, the reliance is on P191, P192, which are minutes of those meetings. Balaj is not listed as attending. For the July 1st meeting, which is P204, Balaj is not listed as attending. For the mid-July meeting, which is with regard to Zarapi, which is P159, T328, there is no mention of Balaj. T3211 lists the people at the meeting, does not list Balaj as attending. And at T3218, which is Zarapi testimony of P159, there is the statement that the next day after the meeting in Yablanica, he went to a meeting in Urznich and he met Balaj at that meeting. Hence, there's clear, it's an inference clearly that can be drawn that he wasn't at the first meeting if he met him at the second meeting, but there's no mention at all of him with regard to the first meeting that was discussed. This chamber has made a ruling with regard to the use of the testimony of Mr. Kabashi, which is that it must be independently corroborated before it can have any weight. That is a ruling that was made, I believe, on the 28th of September last year. I'm not going to dwell on each and every of the assertions made, but only indicate for you that in paragraphs 17, 18, 23, 25, 49, 87, 90, 117, 118, 159, 172, and 273. There is no corroboration for the assertions made. Independent of whether or not there still remains the thorny question which was raised at the time, and one that this chamber must consider, which is that he was not cross-examined. And the evidence that he gave in another proceeding, another trial concerning distinct issues, was not information that was pertaining to or specifically germane to this case at that time. And the failure of the ability to cross-examine a witness claimed as critical, as Mr. Kabashi has been claimed, it was one of the reasons why we've had this retrial. In and of itself should give this chamber great pause for relying on any of his assertions or any of the assertions that the prosecution relies on for his evidence. There's a fair amount of discussion in the prosecution brief concerning what I would call in a general sense victims of the KLA. And in large measure, one of the things that has occurred in this section is that the prosecution has identified an individual as being of a certain ethnic background or of a certain political persuasion, and thereafter made the leap that by virtue of the fact that that's who they were being discriminated against or mistreated by the KLA. However, that's not the case, and the sites relied upon do not support the position taken. For example, in paragraph 49, they cite to witness 66, P107, testimony 8413 and 8416. This is for the assertion that Roma, Egyptian, Kosovo Albanians, as many did not join the KLA and had good relations with the Serbs, and therefore must have been targeted by the KLA. Witness 66 testimony in this regard describes his ethnic background, and he describes the people who were alleged as victims in count 1. He does not testify about the KLA targeting Roma because they did not join the KLA, or because he or any of his family or any of his friends or anyone who was Roma had good relations with the Serbs. They cite in the same paragraph to the notion that the Kosovo Albanians who did not want to fight against the Serbs were victimized by the KLA. They cite to testimony of Avromic, P449 at T6602. It's not what Avromic testified to. He did not testify that KLA victims included Albanians who would not fight against the Serbs. His testimony was rather that in March, April, and May of 1998, he heard from colleagues, he saw reports regarding people who had disappeared. These included Serbs and non-Serbs. They included Kosovo Albanians who were loyal to the state and did not want to fight the state. His testimony in the first instance was unsourced hearsay, but more importantly, makes no reference at all to the KLA. In this case, it's important to note, I raise those with trepidation, those words, res judicata, because there were factual findings made at the first trial that many of the victims attributed to the KLA could not in fact, be connected in any way to the KLA. Those findings remain undisturbed. It also is asserted that the supporters of the LDK were victims, and of course that's a centerpiece of the testimony of witness X's motivations for his journeys back and forth to Pristina because he was a member of the LDK, as well as his perception that there was a active dislike of the LDK by the KLA. Interestingly, one of the documents relied upon is that of Mr. Stojevich, P121, which is used for the proposition that the KLA attacked, quote, collaborators. But what is left out by the prosecution is that in that same statement, it says that in 1997, the LDK publicly stated it was behind the KLA and supporting it. And that can be found at paragraph 20 sub I. There are a series of, not a series, I apologize, there are two Serb intelligence reports that are used for the proposition that Catholic Kosovo Albanians who frequently did not support or join the KLA and had good relations with the Serbs were targeted. We've already discussed in previous argument the issue of the Serb intelligence reports. These reports, which are P34 and P33, literally nothing is said in either of those reports about the KLA targeting Catholics. Excuse me for a moment. I attempted in the interest of time to put the argument together even tighter and have to jump around in what I had previously done. I return now to the artful phrase that is used to define why you should find Mr. Balaj guilty. Unsubstantiated, as I've discussed before, but I want you to spend a moment with it again. His manifest relish for violence as demonstrated by his fearsome reputation is what Mr. Rogers told us on Monday. And in that regard, one of the things that is cited in the brief and is alluded to as a basis for establishing this fearsome reputation and the problems that he posed is that witness 17 complained to Ramush Haradinaj that he had to be kicked out or disciplined for his bad behaviors. And that's to be found in paragraph 33, footnote 119. And if one is to examine specifically what the problem was, it goes like this. 17 is stopped by Balaj. He doesn't like it. And he says to Balaj, when asked for identification, when asked for proper documentation in order to pass, quote, "You self-declared commanders don't have good memories. I was fully armed and in uniform. These are the permissions you are looking for." And specifically in terms of the testimony with regard to the asserted intimidation or concerns that he felt, he stated at pages 752 and 753 of the transcript, "Initially, I tried to consider it as a joke, but when he insisted that I reacted and I asked him whether he knew me, who I was, he said no. I don't know you. Then I showed him an automatic weapon and a few hand grenades, and I told him that I was commander of a brigade and nobody could stop me from going to the military hospital to visit a friend. And that is why I asked Ramush to either dismiss him or to discipline him, because incidents like these could lead to greater consequences." Reduced to its essence, this is not intimidation. This is a professional military man, an older man, taking umbrage at some young upstart, in his view, which he clearly was, some young upstart, challenging his authority. Nothing more, nothing less, and does not serve as a factual basis for the assertions made that Idriz Balaj was the most notorious, brutal, relish, or had a relish for violence. As a matter of fact, witness 17, when pressed on the facts to substantiate such a claim, had no such information. It's been said in more than one culture, of course, that trying to squash a rumor is like trying to catch the wind or water with a net. And a rumor or gossip without a leg to stand on will get around some other way. Going through the prosecution's brief and listening to the remarks that were made on Monday, we think it not unfair to say they're attempting to establish Mr. Balaj's guilt based on bad reputation, which itself is based on rumor and gossip. Bad reputation is not a substitute for evidence. It certainly does not prove his guilt beyond a reasonable doubt. In relying on this kind of thing, they follow at least three improper paths. They violate the fundamental rule of fairness in contravention of Article 21 that prohibits the use of such testimony. They, as I said, attempt to establish the guilt of Mr. Balaj by innuendo arising from gossip and not through testimony that is trustworthy or reliable. And thirdly, they leave him so painted with no means of testing or challenging these unsourced assertions. For what is a rumor? But a cruel story on wheels, and every hand oils those wheels as they run. It's like a virus. It has a viral nature and spins out of control. It has been said about rumors over the years, enemies carry a report different in form than the original. What one invents, the rest enlarge, expand, embellish. Such is the case here. Rumor opens a veritable Pandora's box of irresponsible innuendo and smear. It is not relevant evidence, which in any respect proves a particular fact. Of course, you understand, as well you should, because of where you sit. We're in a court of law, not a coffee shop, not a bar, not sitting at a table where any kind of remarks can be made. Rumors have no role at all in a court of law. And the reputation as characterized by the prosecution as a basis for any finding whatsoever should be disregarded in its entirety. I wish to move on for a moment now to three witnesses. Witness 81, he's been dispensed with, and I will say no more. Witness 75, returning to the guiding principle of reasonable doubt, would you rely on his word? Now, witness 75, he's a proven liar. He lied about his brother. He used his brother's death to further a fraudulent asylum application. In dealing with the most important affairs, he has no compunctions, he has no concerns. He's willing to use the corpse of his brother to achieve his own ends. And you're asked to believe him, to rely on his testimony in deciding aspects of this case. I suggest to you that's a dangerous proposition. He claimed he saw Idriz Balaj at Jablanica. The prosecution made no effort to verify his identification of Balaj. His mother didn't corroborate this identification, and she was with him. They have not approved that this identification is reliable beyond a reasonable doubt, and that is their burden. They have not met it, and they cannot meet it. In any event, he certainly didn't ascribe any behavior of any sort to the man he thought he claimed was Balaj. Witness 80. I've said before that he is either lying or has the mental problems that he claimed in his attempt to evade this court for years. His testimony is not trustworthy. It is not reliable. What he says cannot be objectively considered to be true. And why do I say that? Because in order to accept witness 80 as a truthful witness, you necessarily will have to reject the testimony from at least witnesses 3, 6, 31, 28, 66, Ilber Haskai, and Rustam Tetai. At a minimum. His evidence is like a carton of sour milk. Once you take a sip, you don't have to drink the rest of it. You know from one taste you've got a contaminated product. Once you've tasted it, you don't need any more to let you know what to do with it. As I said, that in order to believe witness 80, you have to reject the testimony of others. Going now to count 1. You have to reject the testimony of credible witnesses who told a coherent story which he did not. He is the only witness to claim the event, like the ear cutting that took place. He cannot name, and he did not name, a single individual other than himself who saw this. It is impossible to corroborate his story. And in looking at the issue of a witness's testimony, I suggest to you there's some questions that you can ask yourself. They're questions that are always asked. Is what the witness said internally consistent? Is what the witness said consistent with the known facts of the case? Is what the witness said consistent with what other witnesses have said? Other witnesses have independently testified to. And how plausible are the statements made? In paragraph 102 of the prosecutor's brief, they say the testimony given by witness 3 and witness 80 shows that 3 people were arrested and mistreated in, and I won't mention the village. That's not correct. Witness 3 never testified to any such thing. 80 is the only one who claimed he saw an arrest, a beating, or an abduction, as we discussed yesterday. Remember something. This village was on alert because of the situation at the time, with the expectation of a Serbian attack. People were on the road, standing guard. There is no evidence at all that these 3 people were targeted because they were Roma or Serb. As I said to you earlier, paragraph 49 cites to witness 66 for such a proposition, and he never says that. There's been a lot of discussion here about one of the elements that you have to decide in any criminal case, which is the when. When did something happen? And here is when did this claimed ear cutting happen? The last person who knew these 3 testified that they left their village on 19 May at 9:30 in the morning. That was witness 66. We have addressed his testimony and the entirety of count 1 in our submissions at paragraphs 158 through 239. We've heard testimony that Idriz Balaj was at Glodjane as of May 14th, 1998, and there was a Serb offensive shortly thereafter in which the Black Eagles were engaged. And we've heard testimony that he was in Gllogjan by March. To the extent that this gentleman's, and by that I mean witness 80's timing can be unsnarled, I think that we can say the following that he claims. Between the 19th and the 21st of May, there was fighting with the Serbs in his village. Thereafter, he was in and I don't know if we need to go into private session for this or not, to name the town.
I don't think there's any problem with naming the town.
Jablanica by the 13th of June. He never said anything at all about an ear cutting. And if it happened after the 13th of June, taking stock with what Mr. Rogers has said, which is the place is so small that anybody who was there knew everything that was going on. Certainly witness 6 would have seen it or heard it if it had occurred while he was there. And we know that he was there from the 13th of June to the 25th of July. So we're clear about something here. And this comes up in another area as well. But P44, which is the testimony of Pekka Havernen, dealing specifically with the issue of whether witness 6 identified witness 80, at pages 6342.
You said P44 is the testimony of?
Pekka Havernen. It's a 92, I'm sorry. It's 92, it's Pekka Havernen's testimony and 92 tour statement. And Pekka Havernen was an investigator for the OTP who went out and among other things was involved in photographic identifications. He's asked the following questions, and he gives the following answer about his encounter with witness 6, specifically concerning the issue of his awareness or knowledge of witness 80. Page 6342. And you asked witness 6 about, you gave him the name of witness, it's a different name at the time, witness is a different number at the time, before you actually showed him a photograph, didn't you? Answer, it's possible, yes. Question, now that was a name that he hadn't given you, wasn't it? If I'm not mistaken, this is probably a question that came from Judge Ori. Answer, no, he didn't give me that name, no. And he didn't recognize the photograph either, did he? No, he didn't.
Please move into private session.
I'm sorry, did I?
Your Honor, we're back in open session. Thank you.
Thank you so much, Mr. Registrar. Yes, Mr. Kasmith.
Suffice it to say, witness 80 has claimed that he was in Jablonica, and the ear cutting that he claimed occurred before. I think I've covered all the times that he's claimed that it occurred. There is obviously a reasonable alternative explanation. That is the one that has been previously adopted and formed the basis of an acquittal, and that is that these people disappeared during the Serb offensive. There's also another reasonable alternative explanation, that which is in reviewing and looking and giving the best consideration you can to witness 80's testimony, that the incident didn't happen at all. And there's another reasonable alternative explanation, which is there's a high probability that Mr. Balaj, who was based on the other side of the Dukagjin zone, was engaged in battle elsewhere and not involved at all, if you can believe that the incident occurred. Moving to count 2. The evidence in count 2 shows that on or about the 20th of May, 2 men were taken by two armed and uniformed men. Those were Uke Rejepai and Nezar Alia, who were the people who were taken somewhere between Gravanic and Dolov. There's no evidence what armed forces, if any, the 2 armed men were affiliated with who took these 2. There's no evidence of the cause of their death. Their remains have not been recovered. They were never seen after the event. There is no evidence that Balaj or anyone in the Black Eagles was involved or aware of this incident before, during, or after. This matter is discussed in our brief at paragraphs 240 to 263. As to counts 3 and 4.
I'm sorry. May we go into private session? I'm very sorry.
May the chamber please move into private session.
Your Honor, we're in open session. Thank you.
Thank you so much. Thank you. Mr. Guysmith, you may proceed.
Thank you. Our submissions concerning counts 3 and counts 4 are covered in paragraphs 264 to 303 of our brief. As to count 3, briefly, witness 6 made no identification of Idriz Balaj as being present during the time that he was in Jablonica. He does not discuss any involvement of Idriz Balaj or the presence of Idriz Balaj in any of the things that occurred to him. Affirmative evidence was received that he was shown a photo of Idriz Balaj on a photo board and did not identify him as anyone he had ever seen in Jablanica. That's P45, paragraphs 8 and 9, paragraph 16, and the associated annex, Annex 6. As I've said to you before, he was there from the 13th of June and released the 25th of July. Witness 6 learned the names of those responsible for his mistreatment. He does not name Idriz Balaj. There's no indication of the Black Eagle's involvement or Balaj's knowledge of the mistreatment of Witness 6 at any time. In the prosecution's pretrial brief, they say that by July 1998, Haradinaj, Balaj, and Brahimaj were at the Jablanica facility on a daily basis, and they cited to Witness 6's testimony as one source. It's to be found in paragraph 20, footnote 97. This is an affirmative misrepresentation of the record. He literally said he never saw Balaj once. They have not corrected this contention and continue to press for a conviction on this count. Count 4. Count 4 deals with Nenad Remistar and one Bosnian and 3 Montenegrin men who show up at the end of June. With regards to count 4, these were the only people other than Witness 6 who were there. There's no evidence as to what happened to them. There's no evidence of their names. And by that I'm referring to the Bosnian and 3 Montenegrins. There's no indication of any Black Eagle involvement or Balaj's knowledge at any time. And there were battles occurring in other parts of the zone, according to Tetai, the Haskai, which involved the Black Eagles. Once again, as said before, there are reasonable, plausible, alternative explanations with regard to Mr. Balaj. Count 5. I'm reminded that they allege that the Montenegrins were never seen again. We don't even know who they are. We have no information at all who they were. They were never identified whatsoever. So the assertion that they were never seen again is one that has absolutely no forensic significance. Because if you don't know, that would be the who question in the criminal case. If you can't answer the who question, you can't draw any kind of conclusions about what happened with them. Count 5. Witness 80 testified that he met Skander Kuchi and offered to help him escape. And, well, we know from Witness 3, who was a named victim in the count, and Witness 6, that that can't be true. If it was, they would have seen Witness 80 and could not have avoided seeing him, as the prosecution has now repeatedly said. This was a small place. And Skander Kuchi was in the same room as Witness 3. In private session. May we move into private session?
Please move into private session.
Your Honor, we're in open session.
Thanks so much. Yes, Mr. Carr-Smith.
With regard to Paul Krasniqi, the evidence established that he was at Jablanica he left Jablanica, and his body was thereafter found at the Lake Radonjic Canal. He left Jablanica in July. His body was found in September. There was another caution given in the first trial. That's the judgment in paragraph 159. And that occurred because of the extensive testimony and battle over the death of a woman named Pejë Balaj. And it was important because Pejë Balaj's body was similarly found at the canal. And it was the prosecution's position that because her body was found at the canal, she was killed by the KLA. That's what the trial chamber says with regard to that, and I suggest the same caution applies here concerning the discovery of a body at Radonjic Canal area. This is paragraph 159. The trial chamber has received extensive evidence, in particular about the perpetrators and circumstances surrounding the death of only one of the alleged murders, namely that of Pejë Balaj. The case of this victim demonstrates the level of caution which the trial chamber should proceed when considering inferences as to the responsibility on the mere basis of the disappearance or abduction of a person and the discovery of the body of that person in the Radonjic Canal area. As the trial chamber will discuss below, a reasonable alternative to KLA involvement in the alleged murder is that Pejë Balaj was targeted by people who were not acting under the direction of or in pursuit of the KLA policies, and that she therefore was not killed in KLA custody. Paul Kajnichi left Jablanica around the 25th of July. His body was found in September. We have information that the wars and battles were raging throughout the area. A reasonable alternative.
Can you cite us to the evidence where it shows that he left on the 25th of July?
On the 25th of July, yes, I'll get the site for
Thank you so much.
I am corrected. I am told that that witness 6 left on the 25th, and that Pal was still there and he was improving physically. So I retract the assertion that he left on the 25th.
Thank you, Mr. Gasman. Are you able to tell us what became of him?
No. Well, we know that his body was found in the Lake Radonjic Canal area in September. That's what I can tell you. I think that Mr. Harvey may be attending this issue in his argument. Right. And the Serbs overran Jablanica on the 2nd of August, but Mr. Harvey, I'm sure, will attend today. Count 6. Now, before we start count 6, I want to get some rules of the road here, because I'm going to be discussing Fadil. I'm going to be discussing the named victims in count 6, who can either be called...
Do you want to move into private session?
Well,
we can move into private session.
Do I want to? No, but perhaps we should.
Well, let's move into private session, please.
Your Honors, we are in open session. Thank you.
Yes, for purposes of informing the public of what is occurring, by virtue of the discussions just had in private session, we will be discussing the last count of the indictment, count 6, and that will be in private session based upon those discussions that have been had. Could we move back into private session?
Before we do that, can we give the chamber a chance? May the chamber please move into private session? I just want to. No, we are not. We are.
Your Honors, we are in open session. Thank you.
Thank you so much.
Shall we deal with it in
Yeah.
open session?
Can you now say on the record that we are going to deal with count 6 in
I am.
open session?
I'm definitely going to say that, Your Honor.
Thank you so much.
After further discussions, we are now going to deal with count 6 in open session, and I thank all the parties for their consideration and analysis in allowing us to do so. Jablanica, as the prosecution has said, is a tiny place where everyone would know what is going on as regards to those who are actually there, that being witness 3 and witness 6 concerning count 6. They never testified to seeing that Nasralika or Fadil Fazio, as claimed by witness 80, were there. Witness 80 says, after an arrest, there were 20 to 30 villages at Jablanica. At that time, witness 80 says that Fadil Fazio was beaten and that Nasralika was not beaten. With regard to that assertion, there is no evidence of personal commission by Balaj of anything. There is no evidence of aiding and abetting by Idriz Balaj. There is no evidence in terms of the testimony that was given of cruel treatment of Fazlio. There is no evidence of torture of Fazlio. There is no evidence of cruel treatment of Nasralika. And there is no evidence of torture of Nasralika concerning the incident, assuming this is when something happened, and there were 20 to 30 villagers at Yab. If that occurred, this has to be in July. But that's if you believe witness 80's recount of what happened to Nasralika. You've got to reject, once again, the testimony of witness 3 and witness 6. You have no choice. You also have to, as indicated earlier, reject the testimony and the reasonable explanation with regard to the issue of battles that was testified to by Rustam Tetai and Ilber Haskay. Now, neither witness 3 or witness 6, as claimed by witness 80's accounting, said there were many other people there. And neither witness 3 or witness 6 said that they saw Nasser Lika there as witness 80 testified. Witness 6 worked in the kitchen.
Did they see Fadil Fazl?
No, he did not. Witness 6 worked in the kitchen. The prosecution has argued that witness 6 failed to identify Nasser Lika and Fadil Fazlio because of the passage of time and because Yablanica was so crowded. Well, first of all, witness 6 had no problem at all identifying Ghani Brahimi, and you can find that at trial testimony pages 5219, 5233, 5236, 5240, in which, among other things, he testifies not only about working with Ghani Brahimi in the kitchen, Ghani Brahimi, I believe, baking bread, but also that he and Ghani Brahimi were witnessing the escape of Skender Kuchi and witness 3. And Ghani Brahimi ran after them. There's no testimony at all from witness 6 that the area where he was detained was crowded, as suggested by the prosecution as a basis for there not being any identification by him. And as a matter of fact, witness 6, as previously discussed, testified that there were few people there, and that by the time that he left, the only other prisoner was Paul Krasniqi. And as I've said before, neither witness 3 or witness 6 testified that they ever saw Idriz Balaj in Yablanica. I suggest with regard to much of this evidence, we run afoul of, or not really run afoul, but are suffering from the problem of when we want the facts to fit the preconceptions the prosecution wants, and when they don't, it's easier to ignore the facts than to change the preconceptions. The fact that the prosecution did not call their own named victim in this count, we suggest allows the chamber to draw the reasonable inference that that named victim, and now I am referring to, I think we better go into private session. Okay, that name victim,
Fadil Fazl.
Fadil Fazl, you're right. I'm being overly cautious. Because Fadil Fazl would not have supported and would have contradicted the assertions made and the testimony of witness 80 as to what occurred. The fact that a conviction is sought at all concerning Fadil Fazl in light of the history of this case and in light of the obligations that the prosecution had that I talked about at the very beginning of this case, to see that justice is done and not to obtain a conviction by improper methods, coupled with their own specific guidelines here in terms of the kinds of information that are to be presented to the fact finder, is shameful. If you,
When,
if
when,
you
when you,
wish
can,
to
when you
accept-
find a convenient moment, do say.
Give me 1 minute. I'll just through this one part. If you wish to accept the prosecution's invitation to engage in the speculation and conjecture with regard to Fadıl Fazlıoğlu, then we're still left with the fundamental absence of evidence for any claim of cruel treatment or torture of him. There's absolutely no evidence of that. We suggest to you there's no evidence whatsoever, but there certainly is no evidence of that if you wish to accept any of the testimony with regard to what occurred by witness 80. And if I'm not mistaken, according to witness 80, the beating of Fadıl Fazlıoğlu took place in front of a number of villagers. That would be 20 to 30. There's no evidence corroborating this claim. Why? Because it didn't happen. In the total absence of evidence, how can we seek? How did they seek? And how could you find a conviction for either cruel treatment or torture of Fadıl Fazlıoğlu? And in the OTP's brief, they specifically discuss issues with regard to Fadıl Fazlıoğlu at paragraphs 67, 87, 188, 196, 197, and 208. If this would be a convenient moment.
Before you rise, Your Honours, may we just go into private session?
May the chamber please move into private session.
Your Honours, we have an open session. Thank you.
Thank you so much. We'll take a break and come back at 1:45. Glodjane.
All rise, s'il vous plaît.